Welcome to the McCarthy Report, the podcast where I, Rich Lowry, discuss with Andy McCarthy the latest legal and national security issues. This week, what else? The latest on the Mar-a-Lago search. You are, of course, listening to a National Review podcast. If for some reason you're not already following us on a streaming service, you can find us everywhere from Spotify to iTunes. And please give this podcast and Andy McCarthy the glowing, indeed gushing 5-star reviews they deserve on iTunes. And now, without further ado, I welcome to this very podcast, through the miracle of Zoom, none other than Andy McCarthy.
Rich, how are you?
Good, Andy. How are you?
I'm good, except I'm having that old Trump feeling again. I had one of these things where I turned my phone off. You know, I turned the do not disturb thing on because I can't remember if I was doing a podcast or something, but sometimes I have this weird thing where the phone, if it rings, it knocks out the computer feed, and for the life of me, I don't understand how it all works. So I turned it off, and I forgot that it was off. And it was one of those days, like for the first time, I thought like I had a couple of hours, I could do some exercise. I had an errand to run, and I had forgotten the phone was off. I turned it back on, and the phone was exploding over Trump news. And I felt like I came back. I complained to my wife. I'm like, it's like we're right back there again with it. Yeah. It's that like 5 minutes of the day where you can just sit back and say, okay. You know, it's like we're back to the. I always thought the oddity of the Trump news cycle was that there was constant thrumming, but you would kind of, you know, you'd get to the end of the month, and the country would be pretty much where it was at the beginning of the month, but you would feel like you had all this, like you were running around on a treadmill, and I just got that feeling all over again.
Yep, it's definitely a 2017 kind of feeling, except one thing has changed from the last couple of years, which is that Liz Cheney is no longer going to be a congresswoman from Wyoming. She was wiped out in the Republican primary. Unsurprisingly, I think the only interesting question was, you know, is the over-under here 30? And will she be over or under? She's under, I guess, 28%.
It's actually, it was up to 37 when I last.
37.
Was it 66 to 29?
Okay. Yeah.
That was
sorry,
the latest thing.
Not the margin. I meant the her overall vote total. Her overall percentage. I would say over under was 30-ish. Maybe you tick it down a little bit. But anyway, she's under 30. Wiped out. What are your thoughts?
Well, I feel terrible about it because I like her. I mean, I also think this was inevitable. Phil has a good piece on the site about how she was already in trouble before she ever got on the January 6th committee. But, you know, I've been thinking about this a lot in connection with Liz and also Adam Kinzinger, who has like, I've got this aversion to him, and I always liked him, which really, it bothers me. But I just think that they missed the measure of what the moment is, in the sense that they're portraying themselves as uniquely opposed to evil, not just like a politics that we reject, but evil. And you know, these are people who used to talk about evil in the context of jihadism, where I was, you know, like mass murder attacks and that sort of stuff. And I just think the truth of the matter is it's very easy, I think, to say and to feel, because I do, that President Trump, that his useful time is up, and that he is a more destructive than helpful force in Republican politics and national politics, without having to like pronounce him and everyone who supports him as evil. I just think it's the wrong way to go. And I think for them, what I think they're missing is a lot of the people on the right, and I count myself among this, see the people that Liz has aligned with against Trump as doing terrible damage to the country. And it really bothers me that she's so full-throated and kind of monomaniacal on the damage that Trump has done, which is very real, while being seemingly insouciant regarding the people that, her new set of allies. And I think that probably grates on people more than I mean, I don't care that she doesn't like Trump. I don't like Trump in the sense that I don't care about him personally, but I would not like to see him be president again. But, we talked about this a number of times. I think you asked me, we had one conversation on this podcast where I sort of said, if somebody asked me who won the Met game last night, the answer to that question is the Mets beat, whoever. It's not the Mets won, just like Joe Biden won on, I mean, that's just, it's too much. It's too obsessive. And the other thing I really think is hurting them and is hurting the January 6th committee is for all the talk about devotion and reverence for the Constitution. They think the Constitution's a very weak document. And I think the most offensive may be the wrong word, but the most unconvincing thing about the January 6th committee is this sense that our democracy was on the brink and we almost lost it. And this conflation of Trump's grandiose but completely half-baked schemes versus their possibility of success, which was non-existent. So this had no chance of working. And it's a moment that if you're an American, you should sit up and be proud that the Constitution was so strong that this cockamamie thing never had a chance. And it's an ingenious system where one person couldn't take it down. And they keep talking like, it's like midnight for the Constitution and it's on the brink and we're hanging on by a thread. And that's just ridiculous. I mean, it's just it's not so. And people who are reverent about the Constitution ought to give it its due. And I don't think they do.
Yeah, I think you put your finger on some important things because you have to admire her principle and her political courage. And she thought this was important. She was going to go out and do it. But there's just something that's rubbed me the wrong way the whole time about it. In part, it's inevitably who her new allies have become. There's some of the kind of fanaticism that has led them, I think, to make some mistakes on the committee and run through what would be a better and more appropriate process, which we've discussed as well. But there's just not like, it's sort of depressing because it shows there's not, I mean, I think there is, and we do it, but there's kind of not a third way in high politics. There's not a third way of Trump criticism. You right. Either end up being, a New York Times columnist in effect and a CNN commentator, or you're dancing around or defending him, which people on the right do. But Liz didn't. I don't think she showed us like what a novel, interesting conservative critique of Trump. It ended up just being allied with all those other people. You know what I mean?
Yeah. I think we have to. I know it's hard to do this, but we have to be the third way. I mean, we just have to be the third, because the third way is the right way, first of all. And it's not a good critique of Trump to disregard everything that he did that was good for the country, and to disregard the fact that he's made it in his sort of bull in a china shop way. He's made it more possible to address things that need to be addressed. He wasn't particularly effective at addressing them, but like he went to third rails and touched them in a way. Like you always talk about the Overton window, right? I think Trump's gift to politics, if there is one, is that, on things like immigration, this was a very stilted conversation before he came along and said, this is friggin' crazy. We got to do something about this. And I think in a lot of ways, he made it possible to advance the ball. That unfortunately, it's not his skill set to actually implement. So, I don't think he did a good job of that. But, there's a way forward without Trump. But it's got to be like being honest about what the good and the bad of it is, and moving on from there. And I think if you're either it's all terrible or it's all wonderful, then you're delusional and you're not going to help anybody.
Yeah. All right. So having praised ourselves for our mode of criticism of Donald Trump, let's demonstrate it, Andy. Let's go out on the field and show what we got. No pressure. You just the whole third way of criticism.
I got it.
Credibility is on you, Andy, right here. Okay. So first of all, let's just do an update since we talked last week. A lot's happened, including especially the release of the warrant and the rundown, at least in broad terms, of what the FBI took in the search. So what did we learn?
Well, I think the most important distinction from what I said last week, Rich, is they figured out a way, which looks to me like it could be a legal way, to criminalize the Presidential Records Act. One of the things we discussed last week, and I was saying, it'd be interesting to see how they would handle this. And I may turn out to be wrong about this because, I thought they would over rely on classified information and figure out a way to scoop up everything that would be legally dubious. And it seems to me that what they've done, I don't like this, but I think it'll hold up. The fact that I don't like something doesn't mean that it's illegal. It won't work. So what they did was, the ostensible reason that they give for having to do this is still the classified information. And, perhaps one of the things I should say up front is that a lot of the discussion about why did they do this is in the nature of like the rationale should be mutually exclusive. And I don't think they are. I think that, there's three different reasons that they did it, and they're not in collision with each other. So they do want the national security information back, but there's only a small amount of that, Rich. There was about 33 or 34 boxes, and all told, and I think I heard Judge Mukasey make this point. He did the math before I did, but there are 11 items of classified information, and out of the 11, only one of them is classified top secret SCI, which is secret compartmentalized information. That's the highest level of classification here. That may encompass special access programs. This is like the highest nature of classified stuff. But, describing it as top secret SCI doesn't really tell us what it is. So we're not in a position to judge whether all that stuff that was floated out there about nuclear information, whether any of that is true or not. But my point for present purposes is there's only one item that fits that description. Beyond that, the other 10 items, there are 4 top secret, 3 secret, and 3 confidential. Confidential is the lowest level of classified information. So that's at a 33.
When we say one item, do we one box or literally one item?
Well, here's what I think they did, Rich. If you notice that if you look at the inventory on the warrant, there's a bunch of numbers of boxes, and then there are some A numbers. And the reason why there's like 45 things that got took out of there, and if you look at the inventory, they only talk. I think the boxes only run up to 33 or 34, is because there's some sub A numbers attached to some of the boxes, not all, about 10 of them. I think it's 11 because one of them is not classified, but it's the Macron file. So there was like a Macron box, and then there's a Macron thing, whatever it is that they took out of that. So what I think they did was, in these boxes, they found some classified stuff. So they took out the classified stuff that they found and kept the box. And the box will be box 1, and the classified stuff they took out of it is 1A. So I think in total there's like 33 boxes, and then there's the stuff that they took out of the boxes and segregated. That's either there's 11, I think, items that are classified, and then there's the one Macron thing that's not classified. But, that's the kind of thing that under the executive order that deals with classification, that's the kind of thing that would be automatically classified if it's foreign policy related things or foreign relations thing. So that's what I think they did. I think when I say items, I think what they did was they took stuff out of these boxes that was classified. Also, now you look at the way the warrant is written, which is amazing. They say in the warrant that, they're looking for classified information, but the warrant specifies that if you find classified information, you can take the box. If it's found in a container, you can take the container. And if there are contiguous containers to that container, you can take those too, even if they don't have classified information in it. So it's written in a way that enabled them to scoop up everything. But what I'm saying is the classified information here is only a small amount of what they got. And the way the warrant is written, that's exactly what they anticipated, because the warrant is written in a way that enables them to take everything. So I think the three things I want to say is they really did want the classified information, number one. Number two, they have had this dispute going back nearly to the time that Trump left the White House, this dispute between Trump and NARA, which is the National Archives and Records Administration, about whose property it is. And Trump has a very sort of pre-Watergate idea that the president's, the materials generated during a presidency are his. They're his property, which is how it was before Watergate. But we haven't been in that world for 50 years or almost 50 years. And the National Archives are like, that's the property of the United States government, and we want it back. And a lot of Trump's rhetoric, which sounds very reasonable on the surface, is not reasonable when you take that fact into account. Trump keeps saying things like, all they needed to do was tell us what they wanted, and if we have it, we give it to them. He sounds eminently reasonable, except if you take the position that the material is the government's in the first place, they shouldn't have to negotiate how much of their stuff he will deign to give back. That's not the way it's supposed to work. And I think he probably banked on the idea that, well, they're never going to do a search warrant or something like that over this. He figured he could wait them out. And I think Richie would have been right if it hadn't been for the third thing, which is I still think that the January 6th stuff is very important. Not just temporally, the way this fits in, but if you think about it, this stuff that ended up in Mar-a-Lago is the stuff that was haphazardly packed over about the reporting says like about 6 hours or so during the last days of Trump's presidency.
That's the way I always do packing, and it's why whenever we're going somewhere or moving, my wife wants to divorce me.
Yes. Well, and my wife says I
throw in boxes.
Yeah, right. And that's where I'd be. Except my wife says the reason that she'd like to divorce me is what she would prefer to do is just take a hook and put it on the side of the house and take that wherever we're going. Yeah. Have you ever tried to get on a plane? You've never tried to get on a plane with my wife is unbelievable because there's like a 75-pound limit to how much you could put in the bag. So we're out on the curb at the party and throwing stuff out of bags. But Trump takes the position that this is his stuff, and they're like, no, this is our stuff. So a lot of that has to do. This is a very Trumpian kind of dispute in that sense. Mm-hmm. And I think if it hadn't been for January 6th, his obstinacy might have worked. But if you think about it, if they threw this together haphazardly at the end, and this is the material, most of Trump's presidential materials were already at the National Archives. So this is the stuff that's late generated more than likely that's in the White House and that they're packing together. So if you were an investigator and you wanted to see what was Trump thinking about, talking about, what were the people around him talking about in the period of time between the election and January 6th? This would be the stuff. This would be much more interesting than other stuff that would be at the National Archives. So I think all these three things are part of this, and I don't think they're mutually exclusive. So again, just to underline it, the de facto criminalization of the Presidential Records Act is saying we want the classified stuff. We think you're obstructing and you might be violating the Espionage Act. And this is the way we get in and we get
vacuum up all the records we want under the Presidential Records Act and poke around for January 6th stuff too.
Yeah, except that the thing I missed on this, which I think gives them a better argument, is this Section 2071. So it seems to me that what they've done, and now they cited 3 criminal statutes in the warrant, Rich, and only one of them really has anything to do with classified information, the Espionage Act. And technically speaking, you can have defense information that hasn't been classified that could be covered by the Espionage Act. So even that act isn't like exclusively about classified information. But 2071 is a kind of an important catch-all. And what I think they've done here is they've stitched the Presidential Records Act, which doesn't have any penal provisions, to this Section 2071 that says if you conceal government files or take government files, that's a 3-year felony. And they've acted as if 2071 meshes with the Presidential Records Act to essentially make criminal something Congress had decided not to make criminal during the Watergate era. And let's remember, when they did the Presidential Records Act in 1978, it's not like they didn't think about crime. Mm-hmm. Ford had pardoned Nixon. There was always a possibility that people were going to get indicted, right? But they decided back then not to put criminal provisions in it. But I looked at 2 things. One is 2071 does apply to government records that they can allege were stolen or concealed. Now, it's got to be willful. You have the whole thing about Trump's state of mind that you have to deal with. But it does give them a broad basis to take stuff that's not classified. And then the other thing I think is interesting, I looked at Rule 41 of the Rules of Criminal Procedure, which is the one that covers search warrants. And it allows the government to take, now they have to plead this in the warrant, the court's got to sign off on it, but the rule says that you can take not only evidence of a crime, but things that are illegally maintained. Now, that provision, I think, is intended to cover things that are obvious fruits of a crime. I don't know, if you sell heroin and you go into a drug dealer's home and you find like a suitcase full of $100 bills, that could be money that's illegally retained, but it's obviously the product of, the proceeds of the other illegal activity that you're investigating. But literally, all it says is if something is illegally maintained, you can take it. So in theory, even though the act, the Presidential Records Act, is not a criminal statute, the government is arguing that Trump's retention of these materials is illegal, and Rule 41, at least literally, would seem to say that if you have something that's illegal, the government can take it.
So, Andy, your theory has been, this is there's pretextual element to this. They're interested in looking for incriminating January 6 documents, and then we've had more January 6 action. We've had the search warrant on Scott Perry, the congressman, next day, maybe, yep. And then things are heating up in Georgia too.
Yeah. So, and also, Rich, our favorite funny guy who comes up in the January 6th committee hearings, Eric Hirschman, has also been subpoenaed to appear at the Justice Department's grand jury. So he's now the 5th White House official who is deeply involved. And you have to clarify, because you don't want to make the wrong suggestion. The people who they're subpoenaing are people who are both complicit and people who fought like hell against these schemes that Trump had to try to overturn the result of the election. Hirschman's on the fought like hell against side of the fence, but those are people who were obviously going to have relevant information about what people were thinking and saying at the time. So I think it just underscored, I mean, that happened I think that happened 2 or 3 days ago, Rich, that it was reported that Hirschman had been subpoenaed. So, they're obviously ratcheting up their activity, and I don't think the Mar-a-Lago thing can be, separated out from that completely. And I also think you mentioned, well, I guess I should say something about Perry. I think, Rich, in connection with both the timing of the search and now the search warrant that was done on Perry. It would be a much different thing if the Justice Department tried to do this stuff while Congress was in session. I mean, first of all, you wouldn't want to have, it would be very controversial if you had FBI agents up on Capitol Hill serving subpoenas on members of Congress, right? It's controversial to serve subpoenas on, or search warrants in particular. It's controversial to do that on members of Congress in any event, because it's, interbranch comity and, how much legislative activity is on Perry's phone that they seized from him. And there's a lot of constitutional issues that arise from doing something like that. And I think, the chances that Congress would scream bloody murder over it would be much higher if Congress was convened. You remember who was the congressman? Was it Jefferson? Was that his name? Or I always get confused if it's Washington. The guy who had the money in the freezer. Remember? Yeah.
I do. I forget.
But Newt Gingrich, who politically was completely antithetical to that guy, was a lion defending him and defending the institution of Congress. And was very offended by the fact that the FBI had done that investigation. It would be a bigger deal for them to be doing stuff on Congress's turf. And I think the other thing is, if you're going to do something like the search at Mar-a-Lago, the protest and outrage about it would be much more organized if everybody was still in Washington. But with everybody hither and yon, I think the Justice Department liked the idea of Congress isn't in session and Trump isn't in Mar-a-Lago. That's the perfect time to go. And I think that has a lot to do with the timing of it. So that's the thing with Perry. And Perry's obviously, Rich, I mean, we've discussed this before. I think they're really trying to make a case on Trump in connection with what they call I guess it's two things: the fake electors that we'll talk about in connection with the Georgia case, and also this scheme by which Trump tries to use the Justice Department to put pressure on the state governments to change the result of the election. And Perry is deeply involved in it. Perry's the guy who introduces Jeff Clark, the Justice Department lawyer, to Trump. Hirschman is the guy who's in the meeting with Clark, as are some of these other people who've been subpoenaed. So it's very clear that that's where the Justice Department is. It's where their focus is now. And if they're not going to charge something out of this, they're sure spending a lot of energy and time on it.
So can we talk a little bit more about Georgia? Because I participated in this debate the other day about whether Trump should be prosecuted. So I was rereading all your greatest hits, and through one of your pieces came across the link to the defense memo by the lawyer for these Georgia fake electors. And I found it pretty compelling. He was making the case that, look, these people were became electors when they thought there needed to be an alternate slate because there was still live litigation around the election. A deadline was going to pass, and if the litigation succeeded, it was unlikely to succeed. But we, or at least you at the time, thought the Georgia suit, looked a little better than the other suits. Didn't go anywhere. But if it did succeed, and there's no alternate slate of electors, Georgia would have no electors. Right. So now you're turning around and saying these people are guilty of a crime for, and they were too optimistic, obviously, probably believe crazy theories. But it's hard for me to see, at least when it just comes to the electors, how they would be guilty of a crime.
Yeah, I think that's right, Rich. And also, if you read the fine print of their motion, which goes into Georgia law, this is kind of what's supposed to happen under Georgia law if you have a disputed election and a deadline comes up and the courts haven't resolved the question yet. You do something that they are very offended at the thought that they're called fake electors because they consider themselves contingent electors. And what they say, and I think they're right about this, is that we never pretended to be the official certified electors from the state of Georgia. We always said we were contingent. The contingency was if Trump succeeded in his litigation or some other lawful way of throwing out the popular election, then we stood ready to be electors, and we made sure to reflect that on December 14th at the time the Electoral College voted, because otherwise, as you just said, Georgia could forfeit all of its electoral votes. But what they say is that became moot because the contingency for which we stood never came to pass. So the whole thing is moot. Now, the other point they make, and this is an important one, there's stuff that happens 2 weeks after the Electoral College meets, right? Eastman and people who he's working with, including this guy Cheeseborough, who is another lawyer who is giving him advice. When they're trying to press Pence into discounting the electoral votes, they say you can rely on these contingent electors. And the Times has had a field day reporting some of the emails that were exchanged between the Trump advisors, which are kind of hilarious to read, because like they're calling them the fake electors. And then somebody realizes we shouldn't call them the fake electors. Perhaps we should refer to them as provisional electors.
Yeah.
They're trying to come up with the right. But, the point is, if these bird brains 2 weeks later decided to use these contingent electors, not for the contingency they signed on to be part of, but as part of the rationalization for the Republican congressman to object to the electoral votes and for Pence potentially not to count the electoral votes, that wasn't the electors' fault. If somebody did something later, that would not have been the electors' fault. What their position is December 14th comes and we're done. We locked in for a contingency, didn't happen, all over. And I think the district attorney, Fannie Willis, who is a highly partisan actor, she knew that.
Great name, though. I love that name, Fannie Willis.
Yeah, take a load off Fannie, right? They knew that at the beginning, because when she first got this special grand jury, she has to get permission from the state court to convene a special grand jury. I didn't know this until I saw an article in the Times today. Apparently, a special grand jury cannot charge anyone in Georgia. The special grand jury gets to issue a report, and if another grand jury that's a regular grand jury that's sitting is persuaded by the report, then they can file charges. So she's in this special grand jury. And when she first reached out to the electors, the first thing you always ask when you get a call, if you're, a person, or particularly a lawyer for the person, if you get a call from a prosecutor who's asking you for information in connection with a criminal investigation, then the first question any competent lawyer asks is, what's my client's status in the investigation? And there's three potential buckets. One is a witness, which is what that means is the prosecutor doesn't think that you have criminal liability, but you have relevant information that's important to the investigation. So the example I always use is the victim in a robbery, who's obviously a necessary witness, but not someone who is suspected of bad behavior. Then the next step up is subject, and it's always easy. Prosecutors usually just say, even if someone has a more serious problem, they always say subject to the investigation. What subject means is you're a person whose conduct is being evaluated in the investigation by the grand jury, and maybe they'll charge you, or maybe they won't. They haven't made they're not at the point where they can make a decision about that yet. And then there's the most serious status, which is target. And a target is someone who is virtually sure to be charged by the grand jury if any charges are filed at all. So being a target is the worst thing that you could be in connection with a grand jury investigation. And it's as much as the prosecutor telling you have a Fifth Amendment privilege to invoke here, because we're looking at you as someone who's likely to be charged with a crime. So those are the three statuses. When the Fulton County District Attorney's Office reached out to these electors, these Republican electors, they told them that they were just witnesses in the investigation. Mm-hmm. And that makes perfect sense given what we just discussed, because there was no reason to suspect that they did anything criminal. Mm-hmm. And what I think is really bad about Willis is a couple of things. Number one, she's got a real pattern in this investigation of telling people they're witnesses and then getting them to do things to their detriment, like cooperate with the prosecutors, and then change their status. And, suddenly they're targets. And secondly, I think what's driving her to change their status is not any change in the evidence in the case, but in the politics of the case. So mm-hmm. What happened with the electors is they get told they're witnesses, they start to voluntarily cooperate, and then the January 6th committee hearings get started. And they have a big hearing about Georgia, and they have Cassidy Hutchinson come in. And all of a sudden, out of nowhere, Willis's office suddenly first tells the electors, while they still thought they were witnesses, on June 1st, they get told that they're getting grand jury subpoenas. Now, if you're a criminal defense lawyer, you're very surprised to get a grand jury subpoena if you're already cooperating with the prosecutor. The grand jury subpoenas basically go to people you have to coerce into testifying because they're not voluntarily testifying. So it seems the defense lawyers theorize, and I think they're right about this, that what Willis was trying to do by giving them grand jury subpoenas all of a sudden was nudge them into taking the fifth. And if you remember, at the same time, what's going on in the January 6th committee, anybody who takes the fifth, they start saying they're guilty of, that taking the fifth is indicative of being guilty of crimes, and that you're guilty of crimes. So what ends up happening is these people are like, I didn't do anything wrong. I'm not, I don't want to go to the grand jury, but fine. Okay, I have a grand jury subpoena. Let's schedule my appearance. So when enough of them said, I think 11 of them are represented by one lawyer, when they said, okay, let's schedule our grand jury appearances, at that point, June 28th, which, by the way, is the same day Cassidy Hutchinson testifies in the January 6th committee, and it's a week after Raffensperger, the Georgia Secretary of State, testifies. On June 28th, suddenly the district attorney of Fulton County tells these electors that they're targets of the investigation, which is that we think we're going to charge you. And I think what she's obviously trying to do is get them to take the fifth. And it's for PR purposes. It's for political purposes, because it doesn't change the case against them. The evidence is the evidence. It's not going to change. And I don't see how what they've done in any way gets altered from. You can obviously see why they're witnesses. If you're trying to make a case on, Trump and Eastman and Giuliani and all these people for what went on in late December, the progression of events, which very much includes getting these electors on the hook, would be important. And you could see why they'd be witnesses. But if they weren't involved in the ultimate objective, if they weren't involved in the scheme, they're not targets. They're not people that you would prosecute over that. Not if you want to win the case. I mean, you don't want to be, charging people on nonsense. So I think this is like totally political.
So what about Rudy? We've also had news about Rudy in Georgia.
So right before we went on, Rich, it's a little before noon on Wednesday. Before we came on, I saw that Rudy had shown up in Georgia today. He had a subpoena to appear before the grand jury today. This was a little comical. First of all, Rudy also says, or Rudy's lawyer, it's mainly Bob Costello who's speaking for Rudy, but Rudy's been out there speaking too. But what they say is that they too were told by Fannie Willis's office at the beginning that Rudy was regarded as a witness in the investigation. And then about 2 weeks ago, they suddenly told him he's now a target in the investigation, which again means someone who's likely to be charged. So at that point, Rudy went in to try to get either to get the subpoena quashed or to make an alternative arrangement so he wouldn't have to go to Atlanta to appear at the grand jury. So they offered to have him appear by video conference. They said no to that. And then he came in and said that he had a medical procedure in June where they put some, a cardiac thing where they put some stents in, and that as a result, the doctor says it's not safe for him to fly. And at that point, Judge McBurney basically made a decision that was very much like it sounded very much like Rudy back in when I was in the U.S. Attorney's office, and you got these mafia guys who came in and said, "I can't travel. I can't. I'm too sick." McBurney said to him, first he gave him a week of an extension in the grand jury appearance, and then he said to him, "Well, there are trains, there are buses, there are even Ubers, but you have to be at the grand jury on August 17th." So the judge was not very sympathetic. And then Rudy tried to say that there's not much he could say because he has attorney-client privilege of Trump's that he has to defend. So he certainly can't discuss any conversations he had with Trump and any activities he undertook because of instructions he got from his client. So it looks like, he's trying very hard not to be pinned into a position where he'd take the fifth after they've told him he's a target. And the other thing with this, Rich, which is unusual, I mean, usually if you told someone they're a target, they're not going to testify, period. And, if I'm representing someone and the prosecutor wants to talk to him, I tell the prosecutor, if he's a target, you give him immunity or he's taken the fifth. I mean, that's the way these things go. Because why would you go in and talk when you don't yet know? The government hasn't had to lay their cards on the table yet. Why would you lock yourself into a position without knowing what they have? I mean, that's just the way this game is played. But with Rudy, it's an unusual situation in that he's talked so much, he said so many things that he may go in there and just decide, he's already got a kind of he sat for an interview with the January 6th committee. I mean, he didn't refuse to testify. He refused to answer some questions, but he didn't refuse to testify. So I think it's possible he could go in there today, try to assert the attorney-client privilege. If a court won't, back that up if they object, he could testify rather than take the fifth. But I think he really, really doesn't want to take the fifth, and they really, really want him to take the fifth, which is why they have him down there.
So just a little time left, Andy. Can we circle back to the Mar-a-Lago search and the issue of classification? Jim Garrity posted on this the other day. You have a rejoinder about to go up on the website, and the obviously it relates to a major defense of Trump that's being made, which is basically he has a magic wand of declassification. So if he's pointing at the stuff, those frantic 6 hours, that's declassified, that's declassified, that's declassified. It's all declassified, and it's his. At least it's not classified. So what's your take on the president's classification powers, and how formal does a declassification have to be?
Yeah, I think the answer is we don't know, and I would say leave it to Jim, who is without peer, to find a case that actually speaks to this issue. Although I don't think it decides it. So Jim, when you guys were talking on the editors, and when Jim wrote the first jolt after he came back from his sojourn, he pointed to the Second Circuit case, which basically says you have to follow formal procedures in order to declassify something. But it comes up in a very different context. The context of the case that Jim is talking about is third party. The name of the case is New York Times against CIA, which is probably a case that could have been brought any number of times over the last several decades. But this particular case, Trump tweeted something about our alleged, you have to say this is alleged because it's never been confirmed, although we highly suspect it and it's widely reported, our government's assistance to the Syrian so-called moderate rebels who were anti-Assad. And what happened was Trump tweeted something about it that acknowledged the existence of the program. Then he said something more in a public statement. And what the argument was by the Times, which wanted to get access to this information through the Freedom of Information Act, that the government couldn't claim under the Freedom of Information Act that the information was classified any longer because Trump had implicitly declassified it by speaking publicly about it and acknowledging it. And what the court said in that situation, where a third party is trying to get information that the government is claiming has never been declassified, and that the president may, whether inadvertently or what, have made some remarks that were improvident, that is not enough to declassify the information such that we have to give it to the New York Times and it can be published. And under those circumstances, the court said, yes, that's true. We're not going to find, without, in the absence of any claim by the government that the information was declassified, we're not going to find in that void of information where there's no paper trail that says that it was declassified, we're not going to find that it was declassified. This is not, I call that situation declassification by implication. That's what they were arguing, that the implication of Trump's remarks, which were not a statement that he was declassifying, they were just a statement about the issue that was classified. The Times was arguing the implication of that is that the information is now declassified. This is a different situation, not only factually, but because we're talking about a potential criminal prosecution as opposed to a FOIA litigation. Here, the issue is the one guy in the government who has authority to declassify says affirmatively, I declassified it. Mm-hmm. So we don't have an information void. We have the government official who could do it saying he did it. Mm-hmm. And the issue is, what does he have to do in order to prove that? So I think there's a good argument to be made, and I am persuaded by Jim's argument to this extent. If the New York Times went in, let's say that the Biden administration foolishly, because they wanted to not, they didn't want to give Trump a defense at trial if they tried to prosecute him. I think, the prudent thing to do here, if you were at all worried that Trump had declassified this stuff, would be to reclassify it as soon as you got it, you knew what it was, right? But let's say the Biden administration didn't do that because they didn't want to make a record that Trump actually did declassify it, which is why we had to reclassify it, right? Let's say they did nothing. And the New York Times comes in and says, we want that document that was down there in Mar-a-Lago. I think probably if the Times tried to do that in a FOIA, the courts would probably find that the information was not declassified, that there's no evidence that Trump actually declassified it regardless of what he said. On the other hand, if you're talking about a criminal prosecution of Trump, where you would have to prove that as a matter of fact, the information was still classified, that Trump hadn't declassified it, and that he didn't know he hadn't declassified it, I don't think you could do that by a criminal prosecution. And it's not clear what the law is in terms of either what a president has to do to declassify, or even whether Congress has the power to curtail the executive branch in this regard. I put in my piece today, there's a very recent, I think it's dated, we're talking August 17th, I think it's August 12th. There's a Congressional Research Service report from just a few days ago where they grapple with this question. And the thing is, the presidents going back to FDR have all assumed that the president had plenary power to classify and declassify. And the courts have assumed that, including the Supreme Court, has assumed that in dicta. But the issue has never come up squarely in a way that the court can rule on it. But like even George Bush, when he signed, Bush was famously criticized by the left for all these signing statements back in the day, right? But in 2004, when Bush signed some counterterrorism legislation, Congress tried to put some limitations on what he could do with classified information. And he said, no, go read your Supreme Court. This is my plenary power. You don't get to tell me what conditions, or you don't get to place conditions on the classification of information. So the executive branch has traditionally taken the position, going back to FDR, that this is a plenary power of the president. And we haven't had a situation yet where Congress actually legislated and said, here's what a president has to do to declassify a document. So if they try to do that, we'll first have the issue of, can they? Like, do they have that power constitutionally? And if they do, will it be upheld in court? So I don't know. I don't think Jim is, I want to be clear, I don't think Jim is wrong. And I think like on his interpretation of the case, I just don't think that it applies to the situation that we were dealing with here. And I hope that if Congress is wise in reading National Review, that they'll do something like what Jim prescribes in his post, because that's the way it should be handled.
So that's all the time we have this episode. This podcast has been produced by the incomparable Sarah Schutte. Thanks everyone for listening, and thank you, Andy McCarthy.
Thanks, Rich.